Good evening, and thank you all for joining us for tonight's webinar. My name is Tasha Bunch, and I am the Program Director here at the Institute for Intellectual Property and Social Justice. Tonight's webinar is part of our Running IP for the People webinar series, part of our entrepreneurship series. And tonight we will be talking about running your business and what you need to know about business agreements. Tonight's session is co-hosted by the firm Allen and Overy, and our moderator tonight is F.A. Kolade. So I will turn it over now to F.A. Thank you.
Thanks, Tasha, and welcome everyone. So the primary goal of our series, which we're having the second webinar on tonight, is to bring the resources of Silicon Valley to other communities of entrepreneurs. So each of the webinars features panelists with extensive industry experience who are going to share some of their insights, anecdotes, and practical advice with the next generation of entrepreneurs. So I'll first give the panelists a chance to introduce themselves. So Katie, if you don't mind starting, and then Shayne and Diana, please.
Sounds good.
Yep. Hi, everyone. My name is Katie Mladinich, and I am a senior corporate counsel at Grail, which is a biotech company using a bunch of complicated AI that's over my head and sequencing to hopefully test people's blood to try to detect cancer before there's any sort of symptoms showing, with the hope that, you know, if you detect cancer early, before it gets too out of control, you can hopefully have a better outcome for the patient. So that's what we're about, and I help out negotiating with a wide variety of different commercial contracts, ranging from like complicated contracts with other big pharmaceutical companies to vendor agreements, and everything in between. So yes.
Thanks, Katie. Shayne?
Hey all, my name is Shayne O'Reilly. I'm a director and associate general counsel in the legal department at Meta Platforms Inc., which is formerly Facebook. As you probably know, we have our kind of social media platforms, Facebook, Instagram. We also have WhatsApp, and then we also have our augmented reality, virtual reality devices with our Quest devices. In my role, I support our legal teams on a lot of our technology transactions and other types of contracts and agreements. We provide counseling on our generative AI issues. We also lead our open source software issues, and we'll talk about open source today. So really happy to spend time with you today and talk about some interesting issues for running your business.
Hi, everyone. Oh, thank you. So hi, everyone. I'm Diana Santos, and I'm the Global Generative AI Lead on the Consulting Legal team at IBM. And my role there is basically about removing all the legal roadblocks that may stand in the way of our consulting businesses strategies involving generative AI, which is, all the rage. Before joining the team, I worked in IBM's global markets legal team, which is essentially the team that supports the sales organization and all that we do to, implement hybrid cloud and artificial intelligence and all our different technology products, cloud services, for example. In both of my roles at IBM, I've entrusted with the responsibility of handling complex legal terms and transactions with our clients under a lot of time constraints. And my journey to this position really began many, many years ago, where I started off my career as an IP litigator and transactions attorney in New York law firms, and then moved down in-house to continue focusing on IP, technology, and data-related matters. So I'm excited to share some of those experiences with you and guide you as you figure out how to run your business. Thank you for having me.
Thank you, Diana. So just jumping right in, we understand that for a lot of you, when you first form your business, the focus is on, the business plan, how you're going to get capital to start up, how you're going to form the entity that is your business, and even like finding a physical space for your company. However, once you're through those initial steps, you have to actually run the business, and you hear about contracts and different agreements that are important to the day-to-day running. Today, we're going to walk through some of those business contract terms and pieces that you should keep in mind as an entrepreneur. And our panelists are going to share some of their experiences about, common pitfalls, as well as things to keep in mind for success. So Diana, just jumping to you, let's start off with a key question. Why should folks devote their already limited time and resources to contracts? Why aren't handshakes good enough?
I am a big advocate for contract hygiene and business hygiene is what I call it, right? Which is making sure that you have clarity on where you stand with both your partners, with your potential clients. And it comes really from my knowledge about IP and making sure that you are owning the property that you are developing, right? You're owning your assets in one way or another, right? I understand that assets can take many different shapes and forms in terms of IP protection. When you're starting off a business, right? You might have, for example, your trademark. You may be brainstorming with somebody on your trademark, right? What rights does your partner or do your other, colleagues have to that trademark? What if you're developing software? There are just so many issues that can come up. And the reality is that the way to think about those issues and memorialize them so that your business can successfully grow is through contracts. If something goes wrong, what I said to you over coffee is not going to hold up in court. And so it's really important to put in some time, some budget, and thought into the types of relationships you're having and how you're going to memorialize them via a contract.
Thanks, Diana. That makes sense. But then once you know that you need to have a contract or an agreement, what types of agreements should folks be focusing on as they start their business?
So there's many agreements that come up, right? So you have your corporate level agreements where you're establishing what kind of entity you are, right? Are you a for-profit, a non-profit? But then once you get those basics started of your company's framework of how you're going to operate as a business, then comes in all the real fun, I think, from my perspective, which is you've got your employment agreements, you're thinking about potentially partnering with people and having joint ventures or joint development agreements. You have third-party agreements in the sense that, you have agreements with people who are supplying the things you need, right? And that can be actual materials or that can be technology. And then you have open source agreements. And that comes up really in the context of, software development many times where you are maybe developing an app or something along those lines and you hire a developer and they're like, well, great, we can take this from GitHub and pull this code. There are terms that are associated with those, the use of the free things, let's say in very layman's terms that you find online, and you need to be aware of what those licenses say so that you can understand whether you in fact will really own the thing that you're developing in the end, because those open source agreements can have a wide variety of terms. And in some cases, you may lose the IP and may have to dedicate it back to the public, depending on the license you have or the license of the thing that you are using.
That makes sense. You mentioned employment agreements at the start there. Can you walk us through what folks should be thinking of as they're building their teams and drafting or getting these employment agreements drafted?
Sure. So an employment agreement is simply what it sounds like, right? I'm sure if you've been employed, you've probably signed something like this. And it's a contract, it's a set of terms that outlines the responsibilities between you and your employer, right? It's the terms of the employment, potentially how long you're going to be employed for, what you are doing in your day-to-day job, what your responsibilities are, what your salary is. And then also the obligations of the employee. And this is where I think maybe sometimes if you're not familiar with IP, you may get tripped up because you're thinking of just the basics and you're not thinking of the work that the person is producing. And so key to employment contracts is the assignment of the intellectual property, all types of intellectual property that the person is creating during the course and in the purpose of their response, related to the responsibilities under the employment contract. So for example, if you have, again, in the case of the software developer, if you have somebody who's creating code for you, you need to be sure that your employment agreement has an IP assignment clause that requires that person to hand over the intellectual property rights to the software that they are developing.
That's a great point. I think you flagged a lot of people might not think about that if they're not attuned to the IP issues. Are there some different types of employment agreements that folks can use depending on who they're hiring?
I think so. I think you don't need, for example, you may not need an IP clause in all your employment agreements, right? If you're hiring just an admin, but maybe in that case, you're going to want some sort of confidentiality protection, regardless if they're, even if they're not, if they don't have to assign IP, they may just have really secretive knowledge of your company. And I think it's generally a good idea to have confidentiality agreements with all your employees or workers for hire. And there are two types of employment agreements generally in terms of the term, like the duration of the contract, right? There's somebody who's at will, and there's another one where you say you're hired for a year, right? And you're going to pay this person set amount for that year. Or maybe they're free. There are many ways of paying and compensating a person, right? So I don't want to tie it to that. It's really about the duration of time. And an at-will employee essentially means that, setting aside any of the things that you're not supposed to be doing, like discriminating, et cetera, you have the opportunity to let the person go in an at-will contract.
Great, thank you, Diana. We have a question from the audience. Is there anything that folks should keep in mind for employment agreements between co-founders, for example?
Employment agreements for co-founders. All right, so the meaning that they're both employed by the company? Just a question back to get a little bit more clarity.
Yeah, I think they mean if co-founders are working together, so should they have some kind of agreement between themselves? How should they navigate that space?
So if they're co-founders and they're employed by the company, right? They have terms not between each other, but with the company, right? They have obligations to the company. And that's the way that setup would work.
Yeah, that makes sense. I think, yeah, if there's a follow-up, we can always address that as well.
Okay.
And then are there any terms that folks should consider in their agreement? So you've talked about at will or specify, like for a specific duration. Once they actually have the type, what kinds of terms should they include in the agreement?
Oh, there's quite a bit, right? I think the key ones are the ones that we discussed, right? Also, what happens upon termination is important, right? You have to the scope of responsibilities, any HR related issues, right? I'm not super familiar with that side of the house, but there are probably a set of HR terms. So for example, if your company has policies or practices that you need to follow, those usually get incorporated into the employment agreement. And there are many ways of doing it. So you can have, for example, a short agreement that then links out to all these policies that you can continue to develop over time. And I think we've touched upon all the most important ones, which are kind of like title, position, salary, your IP assignment clause, any benefits can be included in there as well, the company policies. And then again, my tip here is with kind of just the same thing with any contract is make sure you have counsel that is knowledgeable in the state that you're in, because employment laws vary from state to state, and what may work in California may not work in New York. And so you need to be aware of the requirements under different jurisdictions.
That makes a lot of sense. And now we have another question from the audience, and I guess maybe speaking generally, if there's a departing employee who their contract does not have an IP ownership clause, can the company still claim ownership? Are there ways to do that?
You know, I've never come across this issue. I'm trying really hard. In one way to solve that is to ask the employee afterwards to see if they would be willing to assign it, but that's going to be really tough. I mean, that's really the cautionary tale of why you need it, be that clarity.
Yeah, of course.
And it will depend on it'll depend on many factors. It will depend on, you know, when was that intellectual property created? Was it used being company resources? What other documentation is there to give the, you know, the imply that there's this language in place? It's not going to be easy. The best thing to do in that scenario is to try to remediate it before the employee leaves or after the employee leaves in the best way possible. But ultimately, especially if we're talking, I think about IP that you're going to register, you're going to need that assignment.
Yeah, no, that makes sense. Has anyone else come across that? I know, Diana, you haven't had that situation. Has anyone experienced a situation like that on the panel?
I can't say that I have, but I think Diane does kind of hit on some of the probably tools that people could use in their toolbox, which is explore whether the former employee used company resources or other, you know, aspects of the company to create that IP and possibly use that as a means to somehow suggest that you know, embeddership should be owned by the company. But yeah, it's a tough situation.
And just to throw more fun into the mix, like Diana was saying, with like different state laws, different international laws with IP and ownership rights could apply. Like if you have a remote employee who's in the UK when they're working for you or somewhere else in the world, the IP laws in the UK might be very different in terms of who owns the IP without an agreement and all the factors that play into how to determine ownership in that sense. So it's better safe than sorry. Just get it in writing. And yeah.
I think that's a very good point. I was thinking US centric, but you're absolutely right. The laws are going to differ widely globally. And this is why contracts are important to have in the, you know, before your business really takes off, right? If you're thinking that you're going to be able to grow into a global company and that is your vision, then it's even more critical to have those terms in place at the onset.
That makes a lot of sense. Thank you all for your insights. So just keeping on key terms in employment agreements, Diana, we've already touched on a number of them. Yeah. Are there any more that you can think of that folks might want to keep in mind? Sometimes non-competes are something that people ask about. Anything in that? Oh.
Right. I think the non-competes, I wasn't thinking of that one, but that's an important one because, you know, it depends on where, you know, what you're developing, right? If the space is really limited in terms of competition, you're going to want to consider that. However, you're going to want to be especially careful to make sure that you're not running against any anti-competition laws, right? So the FTC has been active in that space and there is guidance available. I'm sure if you search the internet, you can find it. There's like a short guide on non-compete clauses and how the FTC is looking at those. And it's important to keep in mind that could go wrong for your business, right? If you are really not letting the person seek employment from other employees, because that's from other employers. So that's one thing. And I really do think that policies and practices within a company are important, right? Because it goes beyond the assignment, right? Especially in the case of IP and in the space of generative AI and in the space of open source. If your goal is to ultimately have a product that you can commercialize and say, and copyright, and say that this was entirely produced by a human, then you need to have certain policies in place to determine and to make sure that your developers aren't, for example, using generative AI, right? Which right now, the output is not copyrightable if it was made by a machine, right? So there is now a whole new level of importance to IP given the generation of code via so many different AI models.
Yeah, those are some really great points. Thanks for flagging that, especially the generative AI issues. We have another question in the chat. I think we've sort of touched on this, but asking, as an employee after leaving the company, do you retain rights to your invented work if there was no prior agreement? So I guess you were all kind of saying yes if there's no agreement, right?
I think that's about right. Yeah.
Okay, so hopefully that answers that question for that person. So now just shifting gears a bit to independent contractors. Katie or Diana, I guess, can you just walk us through what that might look like if a company is not at the stage of hiring full-time employees yet?
I can take it. So yeah, so if so full-time employees, first off, are costly. That's why you might be seeing a lot of layoffs in the news lately. Companies are trying to save money, and they can save money by reducing their employee count because you have to take care of healthcare and benefits and bonuses, like employees like bonuses, and maybe you're gonna get free pizza every Wednesday. That costs money, and transit and all that fun stuff. So there's a lot of costs that go in with an employee, and also taxes. Taxes are fun. So you might be thinking, well, if I just need some extra help to get me through these next 3 months, or I just need someone to help me, generate a copyright slogan picture or something, you might not want to hire an employee to do that work. So in that case, you might look for an independent contractor who is not an employee, so you don't have to pay them all the extra benefits like you would a normal employee. You would still need a contract with them, obviously laying out similar provisions that you would have and want your employees to sign, but so you're still definitely going to want confidentiality. You are for sure going to want your IP nailed down for independent contractors, because while there might be some way that you could argue that the company owns the IP, not an employee, independent contractors, it's like a lot more difficult to prove that. It's kind of cut and dry. Like if you have an independent contractor, it's their work. You might be paying for it, but if you don't have it in writing, it's going to be really difficult to get ownership of that work. You want termination. You want to put in writing what you want the independent contractor to do. What remedies do you have if the independent contractor, I don't know, goes AWOL and starts putting out, maybe they're a rogue software engineer who's putting virus code into your software, and then that ruins your entire software portfolio, so you won't need to have all of these in place when you're gonna hire sort of this outside person to help you perform whatever services you need them to provide to help your company grow.
I love the doomsday example, Katie. I really do appreciate it. And it is true. And I just, I don't think we've given any sort of disclaimer yet, right? But the general information we're providing here should not be taken as legal advice. That's not what we're giving. And so I was thinking a little bit more about the question that was just asked about, if I didn't sign anything, is the IP mine? I think you have really good arguments, but you need to, like, especially when it comes to IP, go and seek, a legal advice, get appropriate counsel, and dive into the facts. A lot of issues when it comes to both employment and IP are very fact specific, and you need specialized counsel to handle both.
That's a great point, Diana. Thank you for adding that. And Katie, you did touch on this. There's a question asking about the difference between employees and contractors in terms of IP ownership. So I think you were saying that you're just going to have a harder time making out that the employer owns the IP, right? Is that right?
Yeah, I think to Diana's point just now, there's case law, there's different jurisdictions have ruled different ways based on the facts and all this legal jargon insert here about like how courts have ruled in the past. So if in your situation, you have facts that like match a case perfectly and it comes out sort of on the side that you want it to come out on, it still could happen that the other side wins. Like, you never know in a trial or in a dispute. Those are very costly as well. Like, if you are a startup and if you're just getting off the ground, like, the last thing you need to undertake is a costly litigation. So it's best to get things in writing before you go down that path, sort of hedge your bets. But in terms of employee versus independent contractor, I think there's a lot more case law like that shows that an employee with an employer, there's if you have certain facts, it might be that the employer would own the IP even without writing. But with an independent contractor, I mean, they're independent, right? They're sort of their own person. All the employer is really providing is money. So that's a harder case to prove if you're the employer, or well, if you're the company hiring that independent contractor in that case to prove like, hey, I should own it, even though this independent contractor did everything and invented everything, wrote the software all by themselves, drew this awesome company logo that I'm going to trademark now. That's more difficult.
And it's a different situation depending on the type of IP that we're talking about, right? Mm-hmm. So the copyright laws view on like a work for hire, as opposed to what it means to be an inventor under the patent law, under like the patent laws of the United States, are different. And they're going to also vary globally, to Katie's point. So there's no one easy answer to that question.
Thank you both. Those are great points. And I think just drives on what Diana was saying, just, every jurisdiction is different. So really getting legal advice for your particular circumstance and facts is important. So just switching gears a bit, Katie, what are some terms to think about for joint venture agreements?
Yeah, so joint ventures are sort of their own beast. If you want a complicated agreement that's gonna take time and money to write, joint venture is for you. Where you might want to do a joint venture, however, if you are starting out, and I imagine probably something that a lot of startups need is money. You might have a great idea, you might have a great piece of software, you might have an awesome widget, but you don't have the money to get off the ground with it. So what a joint venture can do, if you enter into a joint ventureship with someone with money, you can get off the ground and start running with that money. Or perhaps maybe you have this awesome software, and maybe your neighbor Bob has an awesome widget, and if you put the two together, you'll make this awesome software widget combo. And so maybe the two of you want to get together and make this awesome software widget combo that could also be memorialized in a joint venture. At its core, a joint venture is bringing together two different parties to execute a very specific, usually it's not going to extend for a long period of time. Usually it's a short duration relationship with these parties focused on achieving a goal for each of those parties. And some components that are crucial in a joint ventureship that are going to be different from other agreements are going to be management of that joint venture. A lot of joint ventures, especially the more complicated ones, like with pharmaceutical companies trying to create a drug, they have, I've seen some agreements with like 10 different subcommittees, and then like each subcommittee has its own subcommittee. And in order to, let's say, for a particular project, subcommittee A first will discuss, and then subcommittee B has to approve. And then if A and B both can't decide, then it goes to subcommittee Z or something to make the final decision. You have all your committees making decisions, and you might think it's tedious and kind of like, well, what's the point if I can just talk with so-and-so and we could get it done? Yes, but so-and-so might be working for a different person, and that different person might have strong thoughts and feelings on how something should happen, and they want to be involved and all this stuff. So it's best just to get that on paper and have both parties agree how management of this joint venture is going to work. Similarly, another really important part of joint venture agreements is percentage ownership, both in terms of IP and also in terms of what each party is bringing to the table. If party A is bringing all the money to the table, at the end of the day, how much IP then should party A get? What percentage of ownership? Maybe you agree on a 50-50 split. Maybe you agree only on a 25-75% split. And that percent also might have an impact then on profits that come out of this joint venture. If you worked with your neighbor Bob to make that software widget combination of awesomeness, maybe Bob, because this widget was super, super inventive and both parties agree it never would have happened without this widget, maybe Bob, should get 75% of the profits and you'll only get 25%. But the flip side of that is if something goes wrong and let's say the company or whatever gets sued by a third party, let's say that widget software combination infringes on someone else's patent, they come after the joint venture and you guys to say, hey, you're infringing my patent, I'm going to sue you for all this money. Maybe Bob, because he got 75% of the profits, he should now have 75% of the damages, and then you'll only pay 25% of the damages. So it gets very complicated very quickly on how all of these pieces are going to work between the partners in the joint venture, which is why I said in the beginning, if you want complicated and long and drawn out, joint ventures are for you. That being said, they can open the doors to many different opportunities that would have otherwise not been available to you. They could lead you to getting the money that you need to get off the ground, or to, open your first storefront. They could pave the way in you expanding into Europe with your product. They could make it so that you create this awesome widget software combination with Bob. So they are really useful, and they can be, but you for sure want to get some sort of legal counsel if you're deciding to go the joint venture route, just because there are so many points of consideration that you need to take into account when you are negotiating and discussing a joint ventureship with someone.
And Katie, if I may, right, you need to be prepared for the divorce.
Yes, right? Yes.
So
exactly.
right, it's like marriage and divorce. So you guys, come together, everybody's happy on the wedding day, and then maybe 2 years later, you call dibs on who owns the cat. Right.
Yeah.
Or right.
You need a prenup. Yeah.
You need the prenup, right? So
yeah.
you need the prenup so that you guys know what you're in for the, if you part ways. And critical, again, I think we need to ring some sort of bell every time we say the word IP, but critical again, IP is huge. So what happens when you divorce or your joint venture dissolves and you want to go back to working on your widget, and Bob wants to go back to working on his widget, or her, whatever, her widget, doesn't even matter, whoever widget it is, what rights do you have to continue to develop those widgets independently? And who owns the rights to the derivative works, which is, again, kind of introducing a little bit more complexity here, but it's about thinking about the future, what can happen, how you part ways, how to use the knowledge that you've gained in the joint venture, and can you continue as independent companies if the joint venture dissolves or terminates.
And those are some really great points. Thank you, Diana and Katie. In terms of just the joint venture setup, what about joint ventures with universities? Are there any differences or things to be aware of, any unique things to be aware of?
Yeah, so and I forgot to mention this in joint venture agreements. Sometimes it's true, sometimes it's not. When I was negotiating joint ventures with big pharmaceutical companies, you had two big players. They each had different amounts of leverage against the other. But a lot of times, especially for entrepreneurs, they are the small fish in the pond, and they sort of the big fish in the pond can, to an extent, force the small fish to do what the big fish wants them to do. This is very true with universities. A lot of times you see a lot of professors, you see a lot of postdocs, graduate students, even undergrads, coming up with brilliant ideas, brilliant inventions in university laboratories. And because the university is funding, usually that research, is providing the laboratory space, is providing the materials, is providing basically everything else besides like the idea to have this invention come into fruition, the university is going to want a cut of that. And like I said, they're the big fish, and they actually get their ways oftentimes because they also have regulations, especially public universities. Those have to abide by what the state where that university is located has sort of dictated that public universities can and cannot do. So sometimes you just might be out of luck with certain provisions. If the university says this is university policy, your joint ventureship is not going to change university policy, no matter how awesome it is. So yeah, spoiler alert. But they can be great opportunities too. And some things to consider with universities, similar to joint ventures just in general and partners just in general, you want to really do your research on the universities and your partners and determine sort of if they will be good partners. Different universities have different reputations in the industry, if you will. Some are very litigious. You know, they are very protective of their IP, and they will go out and actively sue people who they think are infringing their IP. Other universities are like, you know, we're not going to sue anyone. We just like owning it. We'll get some money. It's fine. And others might be completely new and may not have like a university IP department. And they may be like, wait, what is this? I don't know. So you're going to get different levels of sophistication and just different, you know, approaches to IP with universities, like you would with any partnership, really. So it's important to do your homework and, you know, really make sure that the university is someone you want to partner with. If you made your invention inside the university as like a graduate student, postdoc, you might be in a tough spot because you probably have to partner with that university. And some key aspects that the university is going to want that you're going to be really hard pressed to change their mind on is going to be IP ownership. Usually that is some amount of university policy, but it can be linked to, you know, a specific box of IP ownership. Maybe it's just that IP that you invented in that laboratory from X date to X date. If you make it as specific as possible, you're able to put it in a nice little box, opening the door for anything else that you do, you know, after that date or outside of this box. Like you'll own that, but university, yeah, you can get this, you know, this box. And because you own this box, university, and you then are granting me, the inventor, a license to use this box, I will pay you either like an upfront fee, or maybe it's a yearly royalty, or whatever the university and you negotiate on as far as costs, so that you can continue to, you know, practice this box, which is essential for you then to create all this other IP outside. And that's really what the university cares about at the end of the day. Like they like money, they want money. So money, money, money. Like everyone, kind of.
Great, thank you, Katie. Joint ventures sound particularly complicated. So as with everything, we'll encourage folks to, again, talk to someone who is specialized in this area if they're considering joint ventures.
And one other thing with universities that's sort of special, they are notoriously slow. So if you think you are going to sign even like a confidentiality agreement with the university in like a week, no, just like add like an extra 3 weeks on to that, because universities are usually they only have a few people working in their contracting office. They have a lot of agreements to go through. And one of the benefits of working in a university contracting office is like strict 9 to 5 hours. So they're going to work those strict hours and nothing more, nothing less. And they also have holidays. So you have to keep that in mind too. So that's just another extra flavor with universities that you should keep in mind.
Can I add 2 more?
Yes.
So the other level of complexity that I've seen is when you have faculty, especially rock star faculty, that you are trying to engage for some joint development. Things get very complicated fast because their employment agreements with research institutions, academia can be very complicated. They may be teaching at 2 different places or supporting 2 different labs and have different IP terms with each of them and may not be familiar with those IP terms. And so that's another wrinkle to everything. So make sure that, when you're investing a lot of time to partner with somebody who is in academia, that you actually can somehow ascertain that that person that you're talking to also understands the constraints that they may be under in their own employment contracts. And then last one that I could think of is federal funding, right? There are many researchers and innovators, right? Inventors have grants with specific terms. Some of them come from the government, some may come from private entities, and all of those have beautiful IP clauses that can also be limiting in partnership or co-development or joint venture agreements. So there's many layers of complexity when you are working with nonprofit or academic institutions.
Thank you, Diana. Those are great points. Just switching a bit, in terms of when folks are working with suppliers or vendors for their business, what should they be thinking about? Katie, why don't you just walk us through what third-party agreements are?
So third-party agreements are typically more smaller. I'll say they're smaller agreements than your well, they're definitely smaller than joint venture agreements, but they're going to be usually like, I want to buy a widget from this company, and the company's like, okay, here's my agreement that says here's the terms and conditions under which I will sell you a widget. And so you look at that, or you have your own template. That would be even better, that you send the supplier saying, sign my template. That would be ideal, but then you have to get that template. And then it can be for buying parts or for buying services of a third party. So it would be these types of agreements are what you would sign with your independent contractor that we talked about earlier. So same things apply. IP's key. You want to make sure you can nail down, termination rights, make sure you can nail down liability, especially if this is a key part. If you're buying a key component of your invention from this supplier, you want to be sure that, hey, if this component came broken, you got to reimburse me. Or if this component if it had like bad code in it or something, and it ruined your entire process, they gotta ideally be responsible for more than just the cost of the software. Ideally, it would be great if they would also at fault for other consequential damages, but those are a little difficult to get sometimes. But that's the sort of stuff you want to be thinking about, is liability as well. That's important, especially when you're first starting up.
Great point, Katie. And then in terms of vendors and due diligence, can you give us a quick overview of what folks should think about when they're checking their vendors that they might be using?
I think this is similar to just everyday kind of, if you want to hire someone to fix your fence, or you want to hire a plumber to fix your plumbing, just sort of the same things. Do they have a reputation? If they have a reputation in the community, as this happens a lot of times with a previous employer I was at, the suppliers were the only game in town. They knew they were the only game in town, and it didn't matter if the agreement said the cost of the widget is $2, they were going to charge you $4. But they were the only game in town, so you're kind of stuck there. But if they're not the only game in town, and if they have that reputation for breaking agreements, provisions, you might want to try to find a different game in town. Or if they're processing highly sensitive information, and if their process is not up to par, or if there's gaps in their process, where a third party could get in there and do, steal information that would harm you both in terms of this was sensitive information for you, but now you yourself have a bad reputation with your customers. Like, it shows that you couldn't protect their information, and the customers are going to blame you. They're not going to blame this person that you contracted with. They don't even know who that is. So you really want to be sure to do your due diligence when you're picking contractors and suppliers, especially if it's for a key component or key service.
Or I'd add, especially if it's in the space of IT, because cybersecurity and privacy issues will come into play. And if you don't manage that properly according to the many laws that may be applicable to your use of personal data, then you can be subject to high fines.
Yep.
That's a great point. Thank you, Diana and Katie. So Shayne, for these third-party agreements, what are some of the terms that folks in the audience should be keeping in mind?
Yeah, so overall, third-party agreement, you're basically entering into some type of agreement with some type of third party, right? Some external party. You want to be mindful of a lot of kind of the basic terms that you would think with any type of agreement. Dates, key dates, effective date, termination, renewals. You want to make sure that in most negotiations with third party, you want to make sure that there's some type of non-disclosure agreement that's in place that might cover those discussions to ensure that they're confidential. You definitely want to make sure that you might even outline certain timelines or key milestones that may be part of that agreement or that arrangement between you and that third party. What's interesting is, we've run into some situations where, frankly, you have an agreement and there's no termination. For entrepreneurs that are thinking that they might want to sell their company to maybe even a larger entity at some point in time, that larger entity is going to look at all of the agreements that you have with your third parties, and they're going to actually, it could sometimes be frowned upon if there is actually no ability for that entity that's looking at acquiring your business to potentially terminate some of the agreements that you have with some of the other third parties. So when you're entering into any agreement with a third party, you really want to really kind of think of the future in mind, not just kind of think of that agreement or that arrangement at that particular time. Definitely understand there are situations where you may not have as much bargaining power. We've talked about IP a lot. You definitely want to talk about IP, right? Who owns, if you're partnering with a third party and working on specific technology, and using each other's resources or one of the other party's resources or yours, you want to make sure and really think about who's going to own that IP that comes out of that arrangement or that agreement, or is it potentially going to be jointly owned between the parties? IP indemnification is usually a pretty big deal, or indemnification just in general. If you are integrating some third parties software or product into your product and a lawsuit happens and you get sued, indemnification helps determine who's going to pay for that. So you definitely want to be mindful over that type of provision as well.
Great, thank you, Shayne. So we're going to switch over to open source agreements. Can you tell us what those are?
Yeah, so open source agreement, it is a license agreement. It's an agreement that allows one party to basically use the code of another party. That's just kind of at the basic level. There's some agreement that is going to govern the use of that code, or how you use that code, or how you distribute that code. So at a very, very kind of base level, that's what it is. It's just an agreement that outlines how you will use code that somebody else has put out there and made available, or that you are putting out there or making available to others.
Great, thank you. And are there different types of open source agreements?
Yeah, so basic level, and some of you may have heard of this. You kind of have your copyleft licenses and your permissive licenses. So copyleft license is pretty any type of license where the code that derives from your original code inherits your license. So basically, your license runs with the code. Whatever license you associated with it will continue to run with the code If you make it available under that license and somebody else uses it, that license is going to run with the code. And there's more restrictions typically associated with the copyleft licenses. Permissive license is a very kind of free, open, kind of freely available, more open license. We'll give a lot more people freedom to reuse, modify, and distribute the code. Or if you use a permissive license, it gives you that same ability as well. One of the more permissive licenses is the MIT license. Really short. There's not many provisions in there. And it allows people to kind of freely use and distribute code. So those are kind of two of the differences to be mindful of when dealing with open source agreements. Oh, Ife, I think you're on mute.
We lost audio.
Oh, apologies. In the startup context, is there an open source agreement that you would recommend for folks to consider, a specific type?
Yeah, so I'd say I kind of, go back to the general advice, obviously kind of consult a, legal counsel, consult a lawyer that could help you figure out which type of license you think is going to be best for you, whether you're looking for a more kind of permissive license or a copyleft license. Again, as I mentioned before, your more permissive licenses, a lot less restrictions on the use and distribution associated with those. So if you put your code out there and you make it freely available under that type of license and somebody modifies it in some way, shape, or form and uses it, you may not have as many protections. Whereas if you have a copyleft license where your license continues to run with it and there's more restrictions associated with it, you have more ownership over how it's reused and how it's redistributed and your claims over certain ownership rights. So make sure you consult a lawyer and you kind of figure out what is best for you. But those are definitely the concerns and considerations that ultimately come with those types of licenses.
And
Thank you so much.
Jump in really quick here. Regardless of what licenses you use, you will thank yourself in the future if you make a note and keep track of all the different licenses you use.
Absolutely.
Otherwise you'll be playing catch up, which is not fun. So it's best to keep a track. Like
we bring it full circle to corporate, contract hygiene. This is what the housekeeping, making sure you're complying with the terms all matter. And if you'll be sad a few years in if you haven't done that work and diligence.
Yes, of course. Thank you so much for your insights on that, Shayne. And I see we're almost out of time, but we do have one audience question. And I guess this was from earlier. If a university indicated they do not wish to pursue patenting the work, do they still own any ownership of the work? Does anyone want to quickly give us a quick answer to that?
The answer is yes. Because like we said before, with employer contracts, with employees of a university, the university is going to own it, period. Even if they don't patent it, it's still like their invention technically under the employee agreement. So they might not want to patent it, but they'll still have ownership of it. They just want you to pay to patent it because they don't want to pay to patent it. So
right, that sounds like a business decision, not so much a legal decision on their IP rights. Yeah.
And I will say, like, one really, really small caveat: if the university basically decides, if there's something built into an agreement between the individual and the university, where the university gives that individual the right to pursue a patent in the technology, if the university decides not to pursue it. Very rare, but those small exceptions, I've seen those exceptions before, but it's very rare.
Great, that's very helpful. Thank you all. So I'm going to invite Tasha back up to wrap us up. Thank you all again for all your insights and the really rich discussion.